I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my upstanding co-host, Brett.
Hello, Alice. Thank you so much for such a wonderful descriptor. I am upstanding.
Okay. Get the pun. Today, we are talking about standing. And I promise it's more exciting than that. Brett, you are upstanding, but I just love the pun with standing because we are all here today on a day where there has been the latest legal development in the Ellen Greenberg case by the Intermediate Appellate Court in Pennsylvania, the Commonwealth of Pennsylvania. And it is probably not what you expect. There is a lot to discuss in this almost 40-page opinion. And Brett, before we go there, for anyone who may not know the Ellen Greenberg case, this is a case that we covered on our other podcast, the Prosecutor's Podcast. As you all may remember, Ellen was a young woman who was found dead in her apartment, what appeared to be a locked apartment, locked from the inside, with 20 stab wounds all over her body, including her chest, the back of her neck, the back of her head. And at first, the medical examiner ruled her death a homicide, then changed it to a suicide. And now the latest development, it's been 13 years since she died, and her parents have lately brought a lawsuit asking the court to order the medical examiner to now change the cause of death back to homicide. And we'll talk about whether they can bring that and what the lower court did and what this latest opinion said about their ability to bring that lawsuit. And then there's a lot more that the court delves into that is not really before it.
Yeah, this is an interesting case. We've avoided standing as much as we could. We talk about standing every now and then talk about how we're not going to address it because it is the ultimate legal question. Purely legal, real nerd stuff, really complicated, and something people don't understand. And one of the reasons, we're doing this case for a couple reasons. Number one, we cover this, like Alice said, on the Prosecutors. I think we did 4 episodes on it. If you haven't listened to that, listen to it. Not just because we did it, but because this is a case that is really hard to wrap your head around and really difficult to figure out exactly what happened. And you will find yourself thinking about this case long after you listen to the episodes. Not because we're so awesome, but because the facts of the case are mind-boggling. Alice described briefly these stab wounds, but for this to be a suicide, there are so many things. I mean, Ellen essentially was, if you believe this is a suicide, she was in the middle of washing blueberries while her soon-to-be husband was downstairs working out. And then all of a sudden she grabs a steak knife out of the knife block, knocks the knife block over, and starts stabbing herself in the kitchen, both in the back of her neck, ending with a knife wound, plunging the knife into her own chest. And depending on who you believe, some of these wounds may have punctured her spinal cord, rendering her unable to continue to do this. That's a point of debate in the case. There are people who say some of the stab wounds have indications that they were made after she was already dead, at least after her heart had stopped pumping. Obviously, you cannot continue to stab yourself when you're dead. There are so many questions about this case. And as Alice said, initially, the medical examiner, when they looked at this, they said, this is a homicide. And that was what they ruled it. But then, after some questionable medical consults, and if you believe certain people, some pressure from the outside, suddenly this homicide turned into a suicide. And Ellen's parents, they are looking for the truth. They believe this is a homicide, but I think they want the truth. And what they would like is an actual investigation into this case. An investigation that was not done in the beginning. To the extent that while the medical examiner was ruling this a homicide, someone in the police department was giving the apartment complex in which she lived permission to hire a cleaner to clean the apartment from top to bottom, destroying any evidence that might have been there. To what extent an investigation can be conducted, I don't know. But I think one thing everyone can agree on is an investigation should be conducted. And that includes the court we are going to talk about today. Alice said, how did we get here? We got here because the parents of Ellen Greenberg filed a lawsuit seeking to force the medical examiner to change their finding back to the original finding from suicide to a homicide. And they did that in the hopes that that would enable them to bring additional legal challenges they can't bring now, and also to increase pressure on the powers that be in Pennsylvania to actually investigate this case. In the lower court found that they have something called standing. In short, standing means you are able to bring a lawsuit. So imagine, for instance, that something terrible happened to Alice, and I wanted to vindicate Alice's rights, and I want to bring a lawsuit on behalf of Alice. Me, podcast co-host, unless it's something directly involving the podcast, I probably don't have standing to do that. The injury was not to me. I'm not married to Alice. I'm not in sort of a position to do that. There's no redress that I can seek for my personal harms. I can't do that. I cannot stand in her shoes. Some people could. Her estate, heaven forbid, something happens to Alice, her estate might be able to bring a lawsuit. Various other entities. In this case, you have the parents and the estate attempting to bring this lawsuit against the medical examiner. And one of the key questions, there are two big questions in this lawsuit. The first one was, do they actually have standing to do that? Do they have a cause of action that they can bring in a court to go in front of a judge and make an argument where the judge can actually render a decision that helps them? And the second question was going to be, does the court even have the power to do this? Do they even have the power to tell a medical examiner, you said it was suicide, we order you to say it was homicide? And the initial question of standing by the lower court was ruled that they did have standing. And that was going up through the courts because that is a baseline question. If you don't have standing, nothing else matters. Doesn't matter how strong your case is. Doesn't matter how good your evidence is. If you can't bring the case goes away. That's the way our courts work. We don't have advisory opinions. We don't just ask courts to fix things because there's something wrong. You personally, as a litigant, have to be able to bring the case.
And that's a great point, Brett, because it's the first obstacle you have to get through. And that's why when there's a standing question, and you've heard us say this, especially when we cover some of the Supreme Court cases or some cases in other true crime stories that we have covered in the Prosecutor's Podcast, we always say, oh, this is such a meaty issue, but I bet you the court's not going to get to the ultimate issue we all are curious about because they're going to resolve it on standing. And this is baseline incredibly important because what Brett just said, you have to listen very closely. It's not just that you have the right to bring the suit, but there's something the court can do to redress those harms to you. That goes to your standing. And that's why if something bad happened to me, there's nothing that the court can do to alleviate whatever's happened to me for Brett. And that's why Brett doesn't have standing to stand in my place to bring my suit. This is also why when you see cases questioning or challenging big policies, like big healthcare policies or anything like that, it's not just a faceless entity. You usually need like a named plaintiff who has standing to be able to bring these sorts of suits so that they're not what we call advisory opinions. Because you can imagine the court is supposed to deal with case and controversy and not just spout off what they think about the world. Opinions because opinions from on high. That is not their position to do. So with that, in this case, the lower court looked at standing, and that's what we're going to focus on today. And this is going to be important because there were kind of two avenues for standing that the court interpreted at the lower level. And they essentially said, I'm trying to think, I think they were interpreting how the medical examiner interpreted the standing question. Essentially, they said there's two avenues. One of the standing avenues would be that Ellen's parents wanted this changed because they had some sort of stigma attached to having a daughter who committed suicide. And that stigma alone, the medical examiner argued, was not a harm enough to convey standing. And the lower court agreed with them. And so did the appellate court. But the second avenue was really interesting because the second avenue was actually about whether there was some sort of hindrance to either further investigation or other legal matters they could bring if the medical examiner changed the death certificate to cause of death to homicide. This is pretty vague. What sorts of legal ramifications can flow from a change in the medical examiner opinion? The lower court said, yes, we see that there could be other legal rights that flow from a changed cause of death. And because of that, we think that Ellen's parents have standing here. This was the question that the appellate court was asked to review. Was there standing from either avenue, but in particular, the medical examiner appealed the finding of standing based on the reasoning of the second. Was there some further legal ramifications that could flow from the changed cause of death to convey standing to Ellen's parents?
And let's just be clear on a couple things. Number one, when you talk about standing, you are not talking about the merits of the case. And we're gonna say how the court addresses that as we get into this. One of the things we really want you guys to be able to understand is how to read court opinions, because the media is terrible at it. The media only reads the bottom line and acts as if it's the court telling you that on the merits, the court's decided the parents don't have a case here. Clearly, this was suicide. I mean, that's essentially what you get when you read the media coverage of a case like this. But that is not what's happening here. This is a procedural question. And you see this in a lot of cases. We talked about this in the Adnan Syed case. You know, if the Supreme Court of Maryland ends up saying that there wasn't standing for the victim in the case to challenge the overturning of Adnan Syed's conviction, the media will present that as if the Supreme Court of Maryland said Adnan Syed is innocent. That is not what they will be doing. They will be saying there was no standing to challenge it, so we don't even have power to get to that question. And that's what you're dealing with here. And this is not a question of, can the parents stand in the shoes of their child? That is not it. Not in this circumstance. This is a question of, even if Ellen could sue on her own behalf, is there anything that she could even get out of this? And standing, you have to have a real harm that is redressable. And this, the first thing that Alice mentioned, every court that's looked at this tends to agree on. This question of, is it enough to say that suicide is a stigma and removing that stigma and saying she did not commit suicide, she was murdered? Is that enough? We can debate that until the end of time, I guess, but the courts have basically said that's just not concrete enough. Even if it's true, and even if you feel that when you see it, that is not the kind of thing that courts are in a position to redress.
And that's the key right there. This is not about the merits of whether stigma is real or there's real harms that flow from stigma. It's that what can the courts do about it? And this is really important because I think we've come to a day and age where we think that if there's any sort of a harm that you can articulate, then it's the job of the court to redress it. I mean, truly take a moment and pause and think that if stigma for committing suicide were enough to convey harm for standing, what could a court, not a therapist, not media, not public opinion, not reputation, what can a court of law do to redress that stigma? It's really hard to articulate anything. And because it's so speculative and so difficult to articulate, the court is saying, we don't just have this free hall pass to redress all the harms of the world. World hunger exists. That's not our position to just step in general when we see a harm like world hunger to address it. When there's something like stigma and real issues that underlie why there is a stigma or why suicide exists in the world, these are all important questions, but that is not our role as a court of limited jurisdiction.
Yeah, and look, I mean, standing is one of those things you spend a whole class on in law school. There are lots of different ways to think of it. I mean, one way might be, we talked about these big issues. Imagine something like the Affordable Care Act, Obamacare. You know, as an American citizen, the Affordable Care Act affects you in some way. You know, you will pay some amount of taxes to fund it. You know, it might have some real effect on you and how you do healthcare. You alone, as a taxpayer, do not have standing to challenge it. The courts have looked at that and they say, look, it's too amorphous, it's too vague, it's too distant, and we don't want every citizen to be able to challenge everything that happens in the courts. Why? Because that's not really how the whole thing's supposed to work. And this ties in these separation of powers questions and the roles of the courts and what is a court supposed to do. The court is not, despite how it's viewed by a lot of people, courts are not agents of doing good. They are not agents of wandering around looking for harms to fix. That is not what they do. They hear specific cases by specific people that have specific causes of action that can be redressed by the courts in some sort of way.
And I just want to finish that thought because I can imagine a lot of you listening to this thing saying, that's not fair. What about the individual taxpayer who has suffered some sort of harm because of whatever policy? That's not fair. Remember, you do have redress. You can go lobby your legislatures. You can decide who to vote for. And so this is very limited to what the third branch of government can do. So don't, kind of get onto a tangent of, oh, but it's not fair and there's harms here. Again, it's not just the harm. It's the redressability and also the administrability through the court system.
And it has to be something that's not speculative. And that's where the court really hones in here. Because a lot of what the parents were saying, it's not like if the court finds X, Y happens. It's kind of like the underwear gnomes. The underwear gnomes are like the greatest thing that South Park ever did because you can apply it to so many different things. And I don't know if you guys watch South Park, but the underwear gnomes, basically they went around stealing people's underwear and they didn't know why. And so the kids in South Park eventually follow the underwear gnomes. And the underwear gnomes are like, we have a plan about what we're going to do. Step 1, we're going to steal underwear. Step 2, question mark. Step 3, profit. And so many things are that. And standing is kind of like that. So here, the court basically looks at what the family's doing. They say, okay, so step 1 is get this declared a homicide. Step 2, don't exactly know how that's going to go. Step 3, could get restitution from the person responsible. Could maybe sue somebody for wrongful death. There's lots of things you could do down in step 3. But getting there, you have to, there's so many steps you'd have to take. Show who did it, prove that how it happened, show that it was actually a homicide. I mean, just changing what the medical examiner said doesn't prove the case. That's just sort of a first step. And that's essentially what the parents were saying was, look, we need this first step to happen if we're ever going to be able to do the things down the line. And the court basically says, look, we get what you're saying, but you can't show us enough of step 2. And so this becomes very speculative. It seems like you're speculating on what's going to happen if we give you the thing you're asking for.
And that's a great point because in the opinion, we've used the term advisory opinion a couple times. Advisory opinion just means it's not binding, right? It's just my opinion. And they say that about the medical examiner's cause of death certificate. It's advisory. It can be very powerful evidence in a murder trial if the cause of death is homicide. But we've actually seen instances where cases go to trial where the cause of death doesn't match what the prosecution wants it to. It's going to be a hard case, but it doesn't bar you from bringing a criminal investigation. It doesn't bar you from litigating a case. And the alternate is also true. If a cause of death is homicide, it doesn't force the city to open an investigation. It doesn't force the prosecution to bring charges. You can't do that because separation of powers and also because it has to go through the grand jury to be able to have probable cause to bring charges, right? A lot of cases, a crime has occurred. Charges are not brought because there's not enough evidence to bring it. And so because of this, there's all these other steps along the way that are open to other entities and other actors who have agency and do not have to do what the court says, that it's speculative. You think about the domino effect. As soon as the dominoes start moving further and further apart, you can't guarantee that this domino falling will necessarily knock the next domino down. And that's, for me, is a great way to understand speculativeness. The more speculative something is, the further those dominoes are apart, and it's farther and farther, and it's harder to show that one domino falling will cause the next domino to fall and get to the ultimate conclusion that you want.
And let me say this. If you're listening to this and you don't agree, you think this is wrong, you're not alone. This was a 3-judge court, and one of the judges dissented. One of the judges in a dissent actually said, I do think they have standing. And this was the same finding as the lower court. And that judge, in his dissent, essentially said that these things weren't speculative, because if you were able to show that this was a homicide, there's not some big mystery in the middle. You're going to be able to move forward. And just to read what this person said, in the dissent, he's talking about how if you change this from suicide to homicide, the estate has a direct and immediate interest in seeing the impediment lifted. So that impediment is the fact that it's called suicide. That is keeping them from moving forward in a lot of these different legal areas. And that's a tangible benefit in the eyes of the dissent. freeing the authorities to conduct another more thorough investigation, prosecution, and conviction of decedent's murderers, which would entitle the estate to restitution under the restitution statute. Now, here's the thing. There's so much that's interesting about this. I want there to be an investigation. I don't agree with the dissent because there is nothing stopping the state from investigating this case. I hope that the people who have responsibility here are not able to use those statements in the dissent to wash their hands of responsibility in this case, because that's what happens in so many of these cases. I mean, those of you who've had any involvement in politics, you've seen the way politics works, you know how this goes. While this lawsuit was pending, every single elected official, every person in the police, every person in the prosecution's office, every person in the AG's office, including the attorney general at the time it was filed, who is now the governor of Pennsylvania, could say, got to let the courts figure it out. This is in court. We got to let the courts do their job. Don't want to interfere, right? That's what they do because they don't want to deal with what is a very difficult situation. A woman who may have been murdered by her significant other who, just so happens to be a connected person with powerful family in politics. And that has been the big impediment, not what the medical examiner said. And I think if you look at what not only this court did, but what the lower court did, and we talked about this when we talked about this case, and when I talk about reading opinions, this is a 40-page opinion to say there's no standing, we can't consider this case. You do not need 40 pages to do that. You could have done it in 3 pages or 4 pages. You could have just written the standing section and left it alone, but that is not what this court did. And this goes back to how you read opinions. People, they see the top line and they're disappointed and they're upset that the court did this. Read what the court actually said, because this opinion, if you read it, and it's up on Gavin Fish's website, check it out. We'll link it somewhere. You should read it. This opinion, more so than anything, including our own episodes, lays out the case for this being a murder. Goes through every single piece of evidence. And let me just read you how it starts. They, from the very beginning, say, we have no choice under the law but to reverse and remand to the trial court for the entry of judgment in favor of the medical examiner, because there's no standing. If there's no standing, standing is a jurisdictional issue. If there's not standing, the court does not have power to act, even if they want to. They say that. We have to remand, no standing. Even so, in the interest of justice, we believe that providing a detailed review of the victim's death and the ensuing investigation is clearly warranted, with hopes that equity may one day prevail for the victim and her loved ones. That is a message to every accountable person in Pennsylvania. You need to take action. You can't just rely on judges to fix this. There are so many people in Pennsylvania who have the power to remedy this situation and investigate this case, and they need to do it. And the court lays out the argument for why they need to do it in a very powerful way.
And this is why it's helpful to have read many opinions, because anyone who's been to law school or has written opinions, if they clerked for a judge, knows that what do you typically start with? You start with a holding, which happened in this case. A holding is the ultimate conclusion of the court. And then you go into the legal arguments. Not so here. Remember, this is the appellate court. We always talk about how the appellate court is only on the record. The trial court gets to hear testimony, has trial, kind of gets to be in the weeds of the facts. The appellate court has to rely on the record, which is paper. And that's why a lot of appellate opinions are kind of more boring to read, because you're not delving into the facts, and you don't need to. When you've already said on your top line, your very first line of this almost 40-page opinion, we can't weigh into the merits of this case. Procedurally, we have no jurisdiction. Hands up, step back. This is not our case to do. Very important. After stating their holding that they don't have standing, they then proceed to talk about every shred of evidence pointing to a homicide for 20 pages. They don't even reach the legal question of standing until page 20 of the opinion. A 40-page opinion is already very long. So basically, they start with a narrative of what happens the night that Ellen is found dead. And I think it's incredibly important. They go through all of the experts who are brought in, all that her parents have gone through. They show incredible empathy to Ellen's parents, despite the fact that they're just dealing with a standing question. And I point you particularly to footnote 4 in this opinion. This footnote 4 to me is in some ways like, it's not a middle finger so much, but it's like a huge red lines, neon lights. Everyone who has power to do something about this, the governor, the, investigating bodies, law enforcement, look at this footnote. We've all been taught in English class, in law school, your footnotes, you should expect that nobody reads them. So they're typically like short little citations. They don't typically overflow from one page. This footnote 4 goes 3 pages of this opinion. And why it's so long is they're citing to Dr. Ross, who's an expert in forensic pathology and neuropathology, who issues a report with a list of 60 reasons as to why the manner of death should be changed to homicide with a reasonable degree of medical certainty. And the court doesn't simply cite the testimony or the expert report with like an asterisk that says Dr. Ross report, date of report, end. They actually go through and copy and paste all 60 reasons as to why Ellen's cause of death should be changed to homicide. That is huge. In other words, they're saying, we don't want you to have to go look up a report and figure out for yourself what those 60 reasons are. We are reproducing it in this very opinion so that anyone who opens this opinion can look at 60 different reasons that point towards homicide with a reasonable degree of medical certainty. That's huge. I mean, that caught my eye immediately because when you have such a huge block quote of a footnote, it stands out. And again, they're trying to make it easy for anyone who wants to reopen this case. We are writing it all for you here. We can't do it for you. The judiciary doesn't have the power, and they go through in detail why they don't have the power and why there isn't standing. But they don't want anyone to have to go through an extra step, have to open up an extra file to understand why this case should be looked at, why there should be investigation into this case as a homicide.
And oftentimes we do this when we talk to you guys about cases because there is nothing more powerful than a judge saying, I don't have the power to do anything. And by the way, I'm really busy and I got like 1,000 other things to do. But even though I don't have any power to do anything, I am going to spend my time writing this opinion, laying out for you what you need to know about this case. Think all the way back to Temujin Kinsu. That one of the concurrences that we read from in that case, it's a concurrence in a case overturning a grant of a new trial where the judge says, look, I have to agree with the majority because they're right on the law. Now let me give you all the reasons this is absurd and somebody needs to look at this case. We talked about in the Adnan Syed case, the appellate court, who is just deciding whether or not the brother of Hae Min Lee, Young Lee, has standing to be able to challenge the fact that he was given no notice and wasn't allowed to attend the hearing. And then in the footnotes and in the body of that opinion lays out all the reasons that the vacation of Adnan Syed's conviction was unjust. In this case, this may be the paramount example of this. Alice talked to you about the footnote. It's not just in the footnote. I'm going to just read you some of the things from the body of the opinion. So they're going through the facts. They're talking about Ellen's fiance, Goldberg. And I feel like going back to the original case, I always call him her fiance. And I can't remember if he actually is. There's some case where I kept calling somebody a fiance and it wasn't actually a fiance. And I don't know if it's this case or a different case, whether it's boyfriend, fiance, whatever.
I think we've seen that there's a question. I think he was like a fiance or maybe there was a ring that was off.
That's right. There was a ring.
There was a ring that was off.
Right. Well, in any event, I think he actually is her fiance. But if he's not, forgive me, those of you who are pedantic out there. But in any event, his name is Goldberg, and they're writing about this. Mr. Goldberg stated that he returned to the 6th floor accompanied by a building security guard, later identified as Philip Hanton, and forced to open the door. And then they talk about the finding of her body and, the fact that she was dead, and it took him a while to find the knife sticking out of her chest. And then it goes on to say, after taking an initial statement from Mr. Goldberg, PPD officers accompanied him to a police station for further questioning and released him that evening. No summary or other detailed record of that interrogation is included in the record provided to this court, nor was one made available to experts who later investigated the case. Furthermore, there is no indication in the record that Mr. Hanton, who was the security guard, or any other building staff member was ever questioned by law enforcement officials. Astonishingly, in a subsequent written declaration, Mr. Hanton stated that he did not is in italics, accompany Mr. Goldberg to the 6th floor on the night in question, and was not, once again in italics, present when Mr. Goldberg entered the apartment. This is this court who is saying we can't give relief, highlighting for anyone who cares to read all of the issues with this case, and basically saying we can't order you to do this, but you need to do it anyway. You need to investigate this case.
Yeah, absolutely. Like I said, the fact that the footnote has all 60 points, it just shows you how much evidence they're putting into the body of it. And again, they don't even get to the legal issue until 20. I do want to kind of go through those because I see a bunch of questions in our chat like, well, what if we get a bunch of people who came together, a bunch of medical examiners who all agree it's a homicide? Remember, we're not getting to the secondary question, whether the medical examiner can be forced to change their opinion. So let's look at why the court actually decided that there was no standing. It's that number 2 of the underwear gnome analogy that Brett made. Specifically here, the parents had to show what sort of legal relief or legal ramifications would flow from a changed death certificate. And they went through each of them in detail. And this is very, very good. Start from page 20 of the opinion if you want to read the exact reasons. I'll fly through them really quickly, but you'll see why all of the legal ramifications that they're asking for relief on are too speculative or just not available to them. And this may also teach you of how to bring lawsuits as well. You can't just kind of willy-nilly say there's going to be legal relief for me somehow out there. It's possible. I can imagine it. So one of them was whether they could bring a wrongful death suit if it was a changed opinion. The problem here is also a procedural thing. There's a 2-year statute of limitations to bring a wrongful death suit, and the court noted that even if they could bring it, the parents would have had to bring this lawsuit by January 26, 2013. And here we are in 2023. So even if they were able to bring that lawsuit, it is too late. It would get kicked on procedural grounds. So there's no relief in that avenue. Second, the parents had said maybe there's criminal restitution that we could get. Again, this is the domino example. From the medical examiner change in cause of death, you'd have to go through an investigation to find a perpetrator, to bring charges, to then reach a conviction, and then have a court sentence and order restitution for the victim. All of those steps in between are much too speculative to be able to point to say, if we do this, you can then get criminal restitution. But that's kind of where the dissent comes in and says, I don't think it's speculative. We'll put a pin in that one for now. A third one for potential legal ramifications were insurance claims. I know a lot of people were asking, did Ellen have life insurance on her? Isn't that some sort of avenue here? Because a lot, if not all, life insurance plans have a carve out where you don't get benefits from the life insurance plan if you take your own life. This came up in the Alec Murdaugh case. And you can imagine this is to make sure that people in desperate situations don't take their own life if they're in a lot of debt or they want to provide for their family and they think this is their only way out. So for public policy reasons, if you end your own life, I can't think of any life insurance policy that would pay out benefits. So that sounds very promising. If the death certificate were changed, maybe there are insurance benefits that can flow from this. Okay, read the opinion here. The court says, while this is very appealing, nothing in the record for this case supports an insurance claim that could be impacted by a death certificate cause. And so this is too speculative. That should put to bed a lot of your questions as to what about the life insurance plan that was bought? Was it bought by her fiance? Maybe that's a motive. Here, the parents could have and would have argued some sort of impact to an insurance claim if they had one. They've never argued it, and so there's nothing in the record that shows there was an insurance claim on her, and therefore it would be an advisory opinion as to whether a death certificate could potentially impact an insurance claim for some case, not Ellen's case.
And look, I think what you can see here, whether you agree with it or not, this is standing doctrine. There has to be a concrete end. It is not good enough to say something bad happened, and I want the court to make it not bad in you. I want the court to vindicate me and say, you know what, you were right. That is not enough. The court saying you were right is not enough. They have to be able to provide you some sort of relief, something concrete. You're right, and you get an insurance payment. You're right, and now you can bring a wrongful death suit. You're right, and now you can get restitution. There has to be some sort of concrete deliverable at the end that the court can give you. And if they can't point to anything they can do, it's not enough just to say, you're right, she was murdered. That is not enough. That would be an advisory opinion. Courts, like we said, they're not just floating entities of do-gooders. They're not like superheroes in robes. That's not what they do. And you're seeing that in this case. But what the court is trying to do is they're balancing the fact that they lack the power to give some sort of concrete relief with this detailed opinion, laying out all the reasons that the people who can do that, who are in a position to do it, the people you should actually be holding accountable. Everybody's mad at the court because they're not fixing this. It's not their job to fix it. Be mad at the people who are in a position to take this information and actually conduct an investigation. They are the people you need to be holding responsible, and they are there. This court, best case, they could have ordered that medical examiner to change the cause of death to homicide. That's all they could have done. They couldn't have ordered the police to investigate. They couldn't have ordered the DA to prosecute. They couldn't order the AG to put together a grand jury to bring evidence together in this case. They couldn't do any of that stuff.
They can't order the jury to convict.
No.
I mean, this is all very relevant.
But all those entities that they can't order to do those things can still act. The people in
Philadelphia, whether or not, no matter what the legal opinion is here.
Right, and we've seen that. You know, we talked to Broken System, Robert Palmer, when we talked to him about his podcast. You know, he's investigating a case that was originally ruled a suicide, I believe, and subsequently has been changed to be a murder. The reason it wasn't that somebody changed it to a murder and then the prosecutor decided to investigate. It was a new prosecutor who decided to investigate based on some things that DJ Fickey's sister had brought up and evidence that was developed. And eventually this new prosecutor comes in and says, look, I'm going to take another look at this. And after he took another look at it, and with the police taking another look at it, they realized this is not a suicide. They changed the cause of death. And now there's going to be a trial in that case. That can happen here, but it's going to take some public pressure on people who are susceptible to that, which is not the courts. It's not the court's job to listen to all of us. But it is the job of the elected officials in Pennsylvania. And who this falls to, if you're out there and you live in Pennsylvania and you think an injustice has been done here, you need to start mobilizing with your friends and other people who are voters in your state. And you need to be talking to the governor, and you need to be talking to the attorney general, and you need to be talking to the elected prosecutors who have jurisdiction over this case. Because those are the people who can do something. And you really can make a difference here, but you have to be loud, and you have to be persistent, and you have to make it count. It has to mean something to you, to the point that you are willing to speak with your vote and use that vote to move the ball in this case.
Absolutely. And the court essentially says what Brett just says in their conclusion, which I love. So they started out with 20 pages of the facts in this case and why it points to a homicide. Then they have a very, detailed legal opinion on standing, but then they end back with Ellen, because that's what they care about. And I want to read you the conclusion here in case you don't get to this 40-page opinion yourself, because this is as much of a judge putting on paper what Brett just said as I've ever seen. It starts, the facts surrounding this matter are extremely disturbing, and the parents' tireless efforts over the past 12 years to learn exactly what happened to their daughter on the evening of January 26, 2011, warrant our sincere sympathy. The experts they enlisted have all raised serious factual questions about Dr. Osborne's and Dr. Galino's conclusions. And even the medical examiner now concedes that there is, quote, no dispute that evidence in the record could support other conclusions about the manner of death. We emphasize that our ruling expresses no conclusions about the underlying merits of the parents' causes of action. Rather, Our conclusion is limited to the purely legal question of whether the parents, as administrators of the victim's estate, have an interest in the outcome of this litigation that is substantial, immediate, and direct in order to establish standing. We must pose that question because it is not our role to render decisions in the abstract or offer purely advisory opinions. Rather, we may only intervene when the underlying controversy is real and concrete. Because the parents' assertions of standing fail as a matter of law, we are compelled to conclude that the trial court erred in denying the medical examiner's motion. I mean, they are clear about their thoughts of the case and also their role. And by the way, kudos to them for recognizing their limited role in the case. Because those of us who are saying, well, it's so egregious, the court should step in, what can they do here? Remember, what can they do? Brett already laid out all the different actors who can't be ordered to do anything here. And flip it around to an activist court in another situation. Let's flip the situation and say it was a homicide and the defendant wanted the court to order the medical examiner to change it to a suicide so that charges can't be brought against him, or that if charges are brought against him, there's this really bad piece of evidence for the prosecution. And an activist court was like, you know what? I like you, defendant, because you're my cousin's son. Yeah, I'll do that. We would all be up in arms about the judges and the judiciary system sticking their neck in investigations in a way that they should not. So we have these rules for a reason. And this is a sad case, but there isn't anything that the court should do or can do in this instance. And that's what they're trying to convey. But they don't leave out the human element. I mean, saying that they have sympathy for the parents, it's not the role of the court to have sympathy, but they've put this in here because they see what the parents have endured for 12 years on behalf of their daughter.
And I think, this is a great case for that example Alice makes, because if you guys remember when we talked about this, her boyfriend's family was very important in Pennsylvania and in the legal circles and in the courts. They had people in the family who were high up members of various boards that reviewed judges. And you could imagine a world in which a court could do something like that, where the opposite thing happens, where that initial decision not to move it from homicide to suicide gets changed. And you have a court who decides, if they had the power to do it, well, we're going to say, no, it's a suicide. And we're going to order the medical examiner to say it's a suicide. And then what do? Those are the things you're trying to avoid. And it's so easy when you're in these situations and you feel like you know what the right thing is to just think, I don't care about the rules. I just want the court to do the right thing. Go do the right thing, court. And then they do it, and you set a precedent that's going to be abused in the future. Like, we have these rules for a reason. The standing rules are very old and constrain courts in a lot of ways. This is not the court's problem. And the headlines are going to be about the court, but this is not the court's problem. And do not let the elected officials in Pennsylvania get away with convincing you, well, the court's ruled. What are we supposed to do now? No, they all have the power to do something about that. That is what's so frustrating about this case, is there are so many people who, with the stroke of a pen, could investigate this case. They could do it tomorrow. They don't need a court order. They don't need anything to do it. And yet they refuse to do it, and they've refused to do it for 10, 12 years at this point. And that's why this case just drives you crazy, because even if it turns out that after that investigation they concluded it was a suicide, at least you would have a legitimate investigation that you could point to, not this shoddy, just completely incomplete investigation that the court points out all the ways that it's flawed. And like I said, read the opinion. Read those first 20 pages Alice talked about. If you have any doubts about the fact this case needs to be investigated, read those pages.
Absolutely. So the takeaway from this is, if you're feeling rage on behalf of Ellen Greenberg and her family here, feel the rage, but don't misdirect it. Have it be constructive rage. Directing it at the court or at this opinion, or saying the court didn't do the right thing, is not productive. The productive thing is to direct that rage at someone who can do something about it. The prosecutors, the law enforcement officers, the governor. Petition the governor, about doing something here. Elected officials oftentimes lose their jobs in elections when there's enough public pressure about a certain case that they aren't either doing the right thing on. So If you live in Pennsylvania, or you don't live in Pennsylvania, your voice can still be heard. You can still support your fellow citizens who do live in Pennsylvania. But remember, we're not saying don't be angry about this case. There's a lot to be angry about in this case. Just be productive about where that anger is directed.
And I think the anger needs to be pointed in the right direction, and it needs to be for the right thing. No one is demanding that, well, the parents were, but for the purposes of getting an investigation. No one's demanding that tomorrow the medical examiner change the cause of death to homicide, and the next day a grand jury indict the boyfriend. That is not what people want. And I don't think that's what Ellen's parents want. The reason they wanted the cause of death changed was because they believed it was a way to get leverage over the people who could make a decision to reopen this investigation, actually to look into it, to do that. All people want is an investigation, an actual investigation with findings that are supported by facts. Not things like, as the court points out, you say that he broke down the door because the doorman was with him, but the doorman wasn't with him. Like stuff like that. You know, you say you know that she didn't sever her spinal cord because a medical examiner who looked at the spinal cord said she didn't, but that medical examiner didn't actually perform.
Look at the spine.
Yeah, didn't actually look at the spine, doesn't even remember the case, certainly didn't do any microscopic investigation, which they go through in the opinion. Like, there are so many things wrong with this case. And if at the end of the day, they investigate this case and they issue a 100-page report that lays out exactly what they did and why they reached these conclusions, and it's compelling and it's fact-based and it's evidence-based, and it reaches a conclusion that Ellen Greenberg died by suicide, then I think that's something that some people will never agree with, but it's something that I could accept. And I think it would at least give her parents the comfort of knowing someone actually looked into how their daughter died, even if they disagreed with the conclusion. I just don't think this is too much to ask. And I hope that this opinion by the court, this very full-throated opinion, that there is an injustice here, that the people who can remedy it will do so.
So now you guys are all informed about how to read those articles, and you can go read the legal opinion yourself, which you should. Don't let other people interpret it for you, including us. So with that, Brett, do you have anything else you'd like to add before we sign off for the night?
I think I've ranted and raved enough on this. I mean, this case, it's an emotional one for a lot of people for a lot of reasons. And I think, as we said, this is not an easy one. There's a lot of people who are absolutely convinced this is murder, and there are people who are absolutely convinced it's suicide, and I find myself somewhere in the middle. But I don't know how you can reach a conclusion in this case unless there's actually an investigation done, and I just don't think that's too much to ask.
Absolutely. And, you know, we are still, 12 years out? You're right. There is investigation that can be done. The apartment was cleaned, pretty soon after she was found dead, and so a lot of evidence has been lost. But the court laid out 20 pages of evidence to show out a bunch of investigating that can still be done. Not all is lost yet. It will, slips away as time goes on and people's memories continue to fade. But there is still something that can be done, and hopefully what comes from this opinion and what comes from public pressure is that a proper investigation will be done. Well, thank you guys for jumping on with us tonight to talk about this opinion. If there's any further developments, we will absolutely jump on another legal briefs and discuss them with you. But until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs.
People need to understand this was a big deal that they did this, and I know people are upset.
And this is out of the ordinary.
It's out of the ordinary.
I mean, go look at other opinions from this court. I bet you this is one of the longer ones, and I bet you that if you look around, there's no deadline typically. The courts can issue their opinions whenever they want to, and sometimes you'll wait forever, years, for an opinion to come out. look around, look at how many opinions they have coming out and the timing of this opinion. They've prioritized this over other cases. When they're working on this case, they're not working on the hundreds of other cases that they have to write opinions on as well.